So with that, let me see, give me one moment. I am going to share my screen with y'all. All right. So this is your roadmap to divorce. So my name is Lisa Bustos. I am an attorney in Austin, Texas. So this is a very Texas specific roadmap to divorce, in particular towards Travis County, and I am, in the surrounding areas. So, oops, there we go. As I said, my name is Lisa Marie Bustos. I'm a family law attorney based out of Austin, Texas, and I am the owner of Bustos Family Law. I founded my my firm based on the principles of service and integrity. Me and all the people that I hire and work with, we're passionate about guiding people through their difficult times and onto their brighter future. This is going to be your roadmap overview. But moving back, I want to just let you know a little bit more about my firm. We serve Austin, Texas, which is Travis County, and all the counties that kind of touch Travis County. So that's Hayes, Williamson, Burnett, Caldwell, anything that's in the Central Texas area. And we practice family law and only family law. I don't practice PowerPoint, so I'm still getting a little used to it. So thank you guys for allowing me to bumble just a little bit on my PowerPoint. But we do divorce, property division, that's incident to divorce, child custody, child support issues, all of those issues that you may have that are about divorce or the family law process, we can take care of you. So the workshop's purpose of this is to give you that big picture overview of what a divorce might look like. This is a roadmap. It is not intended to be your Bible or your, it's not written in stone. So divorce is, as I tell a lot of my clients, extremely personal. There is no one size fits all when it comes to divorce. And just like your family and you yourself are unique, your divorce is going to be unique to you. So one of the things that a lot of my clients come to me and they ask is, they feel like they should know how to get divorced a little bit because frankly, everybody knows someone who's gotten divorced or who's gone through divorce in one way or another. So it seems like something like, hey, I should be able to figure this out. Well, the reality is that you're not supposed to know how to do divorce. That's why there are professionals like myself, other types of professionals that can help you through this and help guide you through your process so that you don't have to go through this alone and you don't have to bumble through and make mistakes. So the roadmap that we're going to go over today is going to show you some of the common phases of divorce and what that looks like. So here I have the beginning of the suit, the information gathering phase, and the final order phase. There's kind of three main phases and little sub phases between them, and we're going to go through them with detail. I have marked in here, if you notice on the beginning of the suit, the filing of the suit, which has 2 stars, and the final order signed by the judge that has 2 stars, those are the 2 things that are absolutely required within your divorce. So some of these other things are highly dependent on if that's something that your divorce needs. So the beginning of the suit, filing the lawsuit. The divorce process is set up to be adversarial, which is kind of weird, especially if you're in agreement, but procedurally under Texas law, that's kind of what we have and what's required. So you will have a petitioner, the person who files for divorce, and a respondent, the person who is the other spouse who just didn't file first. So the first filing is called the petition for divorce. It's the original petition for divorce. And under Texas law, you have to notify your spouse that you are going to be, that you're going to be filing for divorce and having a divorce in process. There are 2 ways to do this. There's the traditional method where you serve that party by a process server. Again, it's a lawsuit. It's not always the way that some of my clients want to go. Instead, they want to go an alternative method where they notify their spouse, hey, I'm filing for divorce, and we want you to sign a waiver of service. So the respondent will voluntarily sign this document, and they'll say, I don't want to be served by a process server, but I do acknowledge that this lawsuit exists and that this is something that we need to have. Procedurally, Texas has a cooling off period for divorces. So once a divorce is filed, you generally have to wait 60 days before you can complete your divorce. The good news is once that divorce petition is filed, those 60 days have started counting procedurally. The other thing that I need to mention before you file for your divorce is there are some residential requirements as to where you live before you file for divorce. So you have to live in the state of Texas for at least 6 months, and you need to live in the county you're filing for divorce at least 90 days before filing. So sometimes if you're in the middle of a move, that can create a little bit of a question as to where you should file, and sometimes you just need to wait and stay put until you figure out, we're staying in Travis County or Williamson County, and then you can file for that divorce. So the next step within a divorce is, there we go. The next step of a divorce is temporary orders. So temporary orders are there to help establish the status quo of the divorce process. So while you're getting divorced, you're still married, frankly. You're married until you're not, until that judge signs that final decree of divorce. So in the meantime, a lot of people have questions like, where am I going to live and where's my spouse going to live? I don't want to stay in the same house as my spouse. We're not getting along. Maybe we have children. There's a lot of tension. This is not a healthy environment for everyone. And who's going to pay the bills? Is maybe we own a home together and we want to make sure that the mortgage is being paid while the divorce process is going on. Temporary orders can help determine those questions. So they can say, if one spouse has exclusive use and possession of the marital residence, maybe you guys get exclusive possession of your cars, how bills will be paid, who's going to pay them, whether there's going to be temporary spousal support if it's needed. It doesn't happen in every case. If there are children, where are the children going to live and how is visitation going to work? So how are the children going to have contact and regular visitation with the parent that's no longer living in the marital home? There might also be temporary child support, as well as figuring out how health insurance is going to go and some of those other small questions, just to make sure that everybody is supported and everybody knows the rules so that we can keep things as peaceful as possible throughout your divorce process. A lot of temporary orders are determined through a contested hearing. So this typically means that we set a court date, and in non-COVID times, we go to a court hearing and we see what that would look like. So we set a court hearing with the judge on a court date, and a judge will listen to both sides, hear any kind of testimony or evidence presented, and make a court order. Now, one of the things that is important to mention is during a contested hearing, you will probably have to testify. And that's not something that a lot of people are always aware of. But if you have to go in front of a judge, you will have to tell your side of the story, because frankly, no one can tell your story like yourself. And under the rules of evidence, I'm not allowed to tell your story, only you can. So let's see, one moment. There we go. So not every divorce needs temporary orders. This is something that is possible if you guys can't get along. It is an option for you to use. But if you guys can get along and figure out, maybe someone can move out of the house and we don't need a hearing, or maybe we need temporary orders, but we can agree to them. You don't always have to go in front of a judge, and you don't always have to have temporary orders. So the next portion of a divorce is the information gathering phase. So we go through this phase in order to find out information as far as what are your finances like, what are your legal claims like, so that we know exactly what's going on, because frankly, nobody knows your life better than you guys. And so this helps the attorneys and the court figure out exactly what is going on in your life so that we can have orders that make sense for your family. So one of the information gathering phases, or one of the information gathering options that we have is the discovery process. So discovery is the formal legal process of obtaining and exchanging information between parties. So there are actual legal rules within the state of Texas that govern exactly timelines for this, requirements for answering, deadlines. If there is a lack of response, there are consequences to that. So like I said before, the discovery process is intended to give the parties opportunity to learn as much as they can about the other side's claims or defenses before finalizing their case. If someone doesn't respond to discovery requests, they may be prevented from presenting evidence in their case, which can be harmful if they want to, maybe fight for certain pieces of property or fight for certain visitation rights. Failing to respond to discovery can adversely impact your case with regards to property rights and your children. So there are typically 3 types of discovery that are mostly used. There are other options, but I'm just going to go over the 3 most commonly used types today for the sake of this webinar. Like I said, this is an overall view and a 10,000-foot view, so we're not going to be able to get into every nitty-gritty part. But the first part is a 194 request for disclosure. And this, you will disclose any potential witnesses that you have, designate any experts that you have, disclose any legal claims or defenses. And if there's potential parties, like maybe there is a business that your spouse owns, and you need to add that business in as a third party because there was some weird funneling of money into it, you can do that and designate that within your Rule 194 request for disclosures. There's also interrogatories. So interrogatories are a separate piece, and they are written questions to the parties that must be answered under oath. This is sometimes where you get to ask questions like, have you had an affair? Are you giving gifts to other people? Are you receiving gifts from other people? What do you think visitation should look like? What do you think property division should look like? And the good thing about interrogatories is these people are the parties are required to sign them under oath. And that can be used later on to maybe impeach them or hold them to what they said previously. The last piece is the request for production. And this is typically a request for you to produce documents. If a document arguably relates to your case, the other side likely has a right to it. So this can mean something like calendars, text messages, videos, photos, bank statements, credit card statements, credit reports. Usually there's a full disclosure. The idea is that nobody is hiding anything from the other party. Honestly, one of the things that my clients find frustrating is the information gathering phase. This can be an incredibly exhaustive phase. It can be time consuming, and you feel like you're in a waiting period and a waiting pattern with no resolution in sight. But this is one of the most important phases because you're not allowed to hide information from the other party. You're not allowed to hide properties from the other side. If you do, there can potentially be some very serious consequences to that. For example, if you have some questions as to whether or not a spouse owns a bank account that you didn't know about after the fact, and you get divorced, and you can ask the judge to reopen your divorce in order to divide that bank account. And as a punishment, the judge can award that 100% to you, or vice versa if you were the one hiding that information. So as an attorney, I'm constantly encouraging people to give a full, complete disclosure, because hiding things has such terrible consequences, and it can really create a long-term problem for you if you are not honest and upfront. So sometimes parties do not want to go through the cost and all of the rules of the discovery process. So instead what we do is we do something called an inventory appraisement. And an inventory and appraisement is essentially each party's opinion about the identity, character, and value of his or her property. This helps the parties in court ensure that all property and debt has been identified. One of the other pieces that's important to mention about an inventory and appraisement is that there is a verification process that you sign under oath that this is a complete listing of the properties and the values as you believe them to be. If you find out later, oh, I forgot, before the divorce decree, but if you find out later, oh, I completely forgot about this, this one piece of property, you can add it in later and you can supplement. If you make a little mistake, you can supplement it later. The idea is that you're giving that full disclosure. A lot of times this is a time-consuming project on my client's part, but it costs a lot less in attorney's fees. So sometimes my clients will choose to go this route as in an effort to save money rather than going through the process of discovery, which can be quite invasive and quite costly. So once we get through the information gathering phase of your case, there are some final orders that could potentially, so the next part is that we need to get to the final orders in your case. And there are several potential methods in order to get to those final orders. If you'll remember at the very beginning of this presentation, there was a couple asterisks, and the one at the very bottom was that you need a final decree of divorce in order to be legally divorced. So some of the methods that we go over and, trying to get you to that final decree of divorce is informal negotiations, mediation, or final trial. So no matter what happens, you got to get that final decree of divorce if you're going to be legally divorced. So some of the methods that we use for final orders in a case is negotiations. So the positive thing is that this can save you money, especially if you and your spouse communicate well and you're on the same page. There's not much to fight over. We can draft it up into a formal legal document so that you are divorced and you do not have to worry about property division later on or any of the messiness that could happen by not doing a divorce correctly. Some of the negatives of going through this process of negotiation is that a lot of people simply don't see eye to eye. I have a lot of clients come to me and they say, well, we're going to have an uncontested divorce. But the part that is contested is all the terms to the divorce. So they won't quite be in agreement as to how property will be divided or how children's issues will be decided. And so there will be a lot of back and forth of negotiations that can sometimes take weeks, sometimes months, and there's no deadline for a resolution in your case. I have at least one case that we have been in informal negotiations for almost a year. And we've tried to move to some other of these options, but the parties want to keep doing informal negotiations. But there are some, negatives to this. The next part, the next option for you to finalize your case is through mediation. So mediation is a dispute resolution process, and in most cases, you're going to be required to mediate your case before proceeding to final trial. So in the Central Texas area, there are usually, I think every single court that I'm aware of will require you and will court order mandate you to go to mediation. Now, once you get to mediation, the majority of cases settle in mediation, which is a good thing. So what is mediation and what is that process like? So mediation requires a neutral third-party mediator who is certified to conduct mediations. A lot of times, I will like to use another family law attorney who's certified to be a mediator because they have a lot of information, they've tried cases themselves. So sometimes they can give you that third-party opinion and, I don't know if this will go well in front of a judge, or, hey, your case is really strong. We can try to help negotiate for what you would get in front of a judge, or maybe more, or maybe less. A mediator is going to help with negotiations, but they're not going to be a judge or decision maker. The only people who are going to be making decisions in mediation on that day of mediation is you and your spouse. So you may feel pressured to settle You may feel like you're making compromises that maybe you're not 100% happy about, but overall you can live with. Those are your choices. And I tell my clients all the time, you know, this is your choice and this is your life. At the end of the day, the attorneys, the judges, and mediators, we go home. We go home to our own families and you go home to yours. So a lot of times the best money you can spend in a case is mediation, because you're the one making a decision rather than having a stranger in a robe make that decision for you. So if you do come to settlement and mediation, you will have something that is a binding mediated settlement agreement. That we as lawyers, we term it an MSA just for short. But your MSA is incredibly important because neither you nor your spouse can go back on that agreement. It is what it is. You've made that agreement, and you can't say later on, either you or your spouse cannot say later on, hey, I really don't like this agreement. I really don't like what maybe this part I want to tweak or this part I want to change. I'm going to go to the judge and undo this entire thing. You can't do it. The judge doesn't have the power to do it. You don't have the power to do it. You're just going to keep on with your MSA, with your agreement, and make it into a final decree of divorce. So let's say that we went to mediation and you either didn't settle or maybe you got a partial settlement. For example, you had children and you've decided what you and your spouse have made an agreement for the children and an MSA, but maybe not property. So although most cases do settle at least partially before final trial, there is the option of going to final trial. So this is usually a last resort, and this is kind of similar to a temporary orders hearing in that it's a contested hearing, and the judge will hear testimony from witnesses and parties and will decide upon and review evidence that's been presented to him or her, whoever the judge is and whichever county you're in. I know in Travis County, a lot of the judges are women. In Williamson County, it's a mix of genders, and in Hayes County, it's a lot of men judges. So, you know, there's a certain play and strategy that you and your attorney will discuss as to whether or not final trial is the best for you. And then if you do need to go to final trial, how to present evidence so that you are going to be able to persuade the judge in the best way possible. Judges have they have a certain standard in that they're looking at all the testimony and all the evidence that's presented to them, and they are making decisions. But I tell every single one of my clients, you know, imagine that your entire life story, all the memories with your children, all the memories with your spouse is a light in this room, and it could fill the entire room with everything that's happened, and a judge only gets to hear this much and is making a decision. Once that happens, you know, you kind of have to live with that judge's decision. So a lot of times settlement is the best bet, but if you go to final trial, we are building up what your evidence looks like so that it can be the most persuasive to that judge. So at the end of your final trial, a judge is going to make a decision, and a final decree of divorce will need to be drafted by the attorneys and signed by the judge. So a lot of times the judge will render a divorce that day, but we still have to do the paperwork that can take, you know, days, sometimes weeks, depending on the complexity of what's needed. So that's kind of your roadmap for what divorce looks like. If you have any questions, I'm happy to answer them. You can connect with me through my website. My website is www.bustosfamilylaw.com. My phone number is right here, and I'm also on Facebook, Instagram, and Twitter. We have a YouTube account where we post regular videos every Monday that shows, you know, just answer some questions that you might have in the divorce process that are common questions, gives you some insight into what the complexity of a divorce looks like. And, you know, you can kind of do some research through our YouTube as well as our social media, just to see, you know, what our opinions are as to dividing some finances, going after hidden assets, dealing with children's issues. I love to educate as much as possible. I love to connect with people. So please follow us on Facebook. Please find us. We would love to hear any questions that you have. And I will wait around a couple of minutes. If you guys have questions, feel free to type them into the chat and we can answer them, or you can connect with me in another way. Okay, I'm not seeing any questions right now. Okay, so what suggestions would you have about individual preparations before someone alerts their partner about a desire for divorce? So this is a great question. This can be very individualized to the parties in the couple. And I like to ask my clients how they think their spouse will react. Sometimes people have been having conversations about getting divorced for quite some time, and it's just a matter of taking that step into the reality of what divorce is like. And they can do that together as a part of a larger conversation. Sometimes I've had clients who say, I've been talking about this for years, but I don't think that my spouse takes me seriously. And so I need to file for divorce and have this conversation. So a lot of times I will sit there and prep with my client as to, truly putting themselves in their spouse's shoes and thinking about how they're going to respond. And then we make preparations that way. Every spouse is different, so there's not a straight line method. I highly encourage that all of my clients go to therapy. It helps people process their divorce and the grief that a lot of people feel in filing for divorce, whether they are prepared for it or not, or whether they're the ones filing for it or not. So I think that, it's a very individual process. Align what your goals are, think about what your goals are for the divorce, and really start talking to them. So the next question is, what are some common mistakes people make during the different phases of the divorce process? Some very common mistakes that I see is people who they have a hard time regulating what their emotions are and what their behavior is. And so I work with my clients a lot to try to differentiate what your emotions are and what your behavior is, because a lot of times, people can't, and they behave based on their emotions. So you're going to step on your spouse's toes, and your spouse is going to step on your toes, and that's just a part of the process. There's going to be times when you're going to upset each other. But behaving on all of those, on all of those toe steppings, I should say, can really cost you a lot of money, cost you a lot of heartache, and cost you a lot of stress. So again, it always helps to go to therapy to kind of work that process out so that you're not running to your attorney, trying to get into the courthouse every time your spouse makes you slightly upset. So if there are any other questions, I love the questions that you're asking. I really appreciate it. So I am not seeing any other questions, but I truly appreciate everyone joining me today. And if you have any questions, feel free to reach out to me, and I hope you have a great day.